today, and with me in spirit, as I am with him, is my colleague in Connecticut, William Tong, a Brown University graduate who also likes to fish in Rhode Island waters. So I know he's here in spirit. As I said, I am with him. We're here to announce today the filing of a lawsuit against the Trump administration here in Providence Federal District Court in connection with the administration's abrupt shutdown of the Revolution Wind Project off the coast of Rhode Island in late August 22nd, to be exact. You know, when I thought about why we're bringing this lawsuit, it's really a story of numbers that have already been reported by all of the media members in this room. We know how much energy it's going to generate, clean, reliable, renewable energy, 704 megawatts, 400 for Rhode Island, 304 for Connecticut. It'll power 350,000 homes. It will enhance the reliability of our grid. I thought it was extraordinary, as I said, I believe last week when I spoke on this issue in Newport, dressed slightly differently, that it was extraordinary that ISO New England said what it did about how important this project is to the reliability of our energy grid when the need for energy is at its peak. And that's probably explained in some way by the fact that because of AI that I have mixed feelings about, and other things, our demand for energy is increasing where it had been stable for some time. So this is a project that is important, beneficial, clean, renewable. And I think most importantly, for purposes of this lawsuit, it is a project that is 80% done. This is not a project that is one of conception. It's not one where plans are drawn on paper. And I want to be clear, from where I stand, those projects are really important. And we have begun, if not built, an industry here in Rhode Island that can continue to grow and provide jobs for Rhode Islanders and build our economy. And through the building of that economy, fix a lot of the problems we're facing here in Rhode Island. Better, higher paying jobs mean better access to healthcare. It means better access to housing. And so we're on the cusp of building that industry, and the president abruptly halted it unlawfully. But what stands out most about this project is, even if you're looking at it just in a vacuum, is that it is 80% done. As has been, again, well explained by others before, 45 of 65 turbines have been installed. All the foundations for the turbines have been installed. The cabling is largely done. 90% of the facility at Quonset where the electricity will come on shore is done. And so that creates some reliance interests, separate and apart from the company in Orsted. They have their own interests to pursue. This is about Rhode Islanders and what Rhode Islanders need, what Rhode Islanders are relying on, what Rhode Islanders are counting on. And words with the Trump administration, as I think has been demonstrated, are simply not enough. What's required with respect to this administration is action, and that's what we're taking today. On that note, I'll digress just a little bit. I asked the team over the weekend, because I hear a lot about how many lawsuits I have filed on behalf of Rhode Islanders against this administration. And I don't keep track of the numbers. I don't. We keep track of the cases, but not the numbers. What matters to me is whether the Trump administration has violated the law, whether Rhode Islanders have been harmed as a result, and whether we have legal standing. And to date, we have recovered nearly $650 million alone for Rhode Islanders that we would have lost had this office not taken action. $650 million. And so that's the number that Rhode Islanders should think about when they think about whether these lawsuits have had impact. Not how many lawsuits there are, but how many dollars we've brought back. And there are more dollars in the pipeline. And so with that, I'll just briefly mention what the claims are about. It's basically that you can't run a government like a yo-yo. The president may be like a yo-yo, bouncing back and forth between positions, whether it be tariffs, foreign policy, or anything else. And if he wants to behave like a yo-yo, that's up to him. But you can't run government that way. That's what the Administrative Procedures Act and other federal statutes at play here are about. That decision-making has to be rational. And it has to be rational because not only do Rhode Islanders, but industry relies on predictability and rationality. Stopping this project at this point in time is hardly rational. It's just the opposite. You know, it reminds me a little bit of the work we have done here in the office, led by the great team behind me, Sarah Rice in particular, involving the CRMC and things like Champlain's, where you know, state agencies don't follow our own Administrative Procedures Act and make decisions and put their findings on the record so that they can be reviewed by a court. That's how agency action is supposed to work. You make a decision, you explain why you made the decision, you explain how the law and the facts come together, and then a court can review it. You don't just take agency action by saying, this ends now. And whether Pam Bondi is saying that in the context of immigration enforcement, or that Trump is effectively saying that here, that's not the way government works. It's not run like a yo-yo. So with that, I'm going to stop. If there are any questions, I'll take them. I do want to introduce the staff. Lenny Giorano and Nick Vaz are to my right. Nick in particular is highly schooled in this area. He does all of our energy work. He understands way more about this than I do. And so if you have questions that I can't answer, which is likely, Nick's the person I'm likely to turn to. And then on this side, I have Pat Dolan, who is our Chief of Policy, and Sarah Rice, who leads our public protection unit. I also want to say, because I think we hear this a lot, those of us who believe in renewable clean energy, that this is going to cost Rhode Islanders more. Just the opposite. Stable energy prices will cost Rhode Islanders less in the long run. What we see every year are spikes in our energy costs, and whether you heat your home with oil like I do at the moment, although heat pumps are coming, I'm glad to say, this fall for Shelley and I and our family. You know the spikes in oil prices. You know the spikes in gas prices. We know the spikes in electricity generated by gas. Wind energy is reliable, and it's because of that stability and reliability that Rhode Islanders can count on should this project and others that are following in its wake, they can rely on renewable, clean energy that will keep their prices for energy stable. So with that, I'll stop and take any questions you have.
Peter, the president argues, and other opponents of wind power argue, that the adverse effects of wind power are greater than the benefits in terms of the effect on the environment, the fishing industry, et cetera. Why are they wrong in their argument?
Well, there's lots of reasons, Ian. You know, what I find remarkable is we don't hear about the adverse environmental effects for wind farms all across this country. I drove my son back from Wichita, Kansas a couple summers ago. There were turbines in every direction. The president is bringing an all-out assault on wind. I read some reporting recently that he is against or is taking on or attacking or to stop an energy transmission line that would bring clean renewable energy from Kansas to Indiana. Why? I have my theories. Many of them involve the fossil fuel industry that may have the ear of this president. But all of the research, whether it's land-based wind energy or marine-based offshore energy, wind energy, all of that has been debunked. There are fishermen that are earning supplemental income from working on Revolution Wind and are grateful for it. There's been reporting on that out of Fall River and New Bedford. So the president is plainly wrong, and for whatever reason, this is in his head. notwithstanding the obvious benefits of the industry.
Are you seeking court action that would speed the resumption of work on Revolution Wind?
Absolutely. Yes, that is correct. We are looking for injunctive relief to bring this project back online. Look, you know, when I live in Jamestown, as almost everybody in Rhode Island knows by now, and while I don't live on the water, when I'm driving to and from home, or when I'm out on the bay, I certainly see what's out there. And there's a lot of ships. Last night I was counting, just on an app that I have alone, 5 ships related to wind energy that are just sitting out there in the bay that would be out there putting Rhode Islanders and others to work on this project. And it's just a waste of money and a waste of time. And the longer that those ships sit there without doing anything, the more likelihood that this project literally sails away.
What is the expected timeline before a decision is made on that injunctive relief?
Well, hopefully as quickly as possible, Ian. Yeah, the goal is to have this be done as a matter of days, at most weeks, not a matter of months. And I think that's something else that is lost in some of the work that we've been doing. We've been getting injunctive relief here in Rhode Island, across the country, which has allowed us to save that $650 million that I referred to earlier. It's not like, you know, we're fighting this out that's going to take 2 or 3 years. We've been able to get results very quickly.
One more, can you quantify the dollar impact for Rhode Island and Connecticut of the stop work order, if that is upheld?
If it is upheld, quantify it. I can't quantify it. I can put into categories of things that it will do. It will destroy, in my opinion, the wind industry, because if a project that is completely permitted over a period of 10 years, as our complaint alleges, can be stopped in its tracks without any rationale or reasoning, then why would anybody invest in anything, particularly the wind industry, under this, while this president is in office for 3.5 years? So certainly it will bring a thriving and a growing industry to a halt, which is bad for Rhode Islanders in terms of our economy. It will be bad, as ISO New England indicated, for the reliability of our grid. In the long run, it will raise costs. Certainly our costs will continue to have for energy. We'll have these wild swings back and forth as we see. And one of the things that I have to say that has been most frustrating as Attorney General has been our inability, as hard as we have worked on some of these energy cases, and it's through no fault of the staff, for example, on the PPL purchase of Narragansett Electric, as hard as we fought in that case and saved Rhode Islanders a lot of money, Rhode Islanders are very concerned about energy prices. And the reason they're concerned is because of these swings, not just between summer and winter, but year over year. And so there are lots of ways, Ian, that Rhode Islanders and people of Connecticut will be impacted, but in terms of a dollar amount, that's very, very hard to do.
You mentioned,
Yes, Steve.
You mentioned the impact on the industry, but there's other projects in the pipeline.
Yeah.
And will this lawsuit in any way inoculate those projects from the same?
Well, it should, Steve, in the sense that if we get the relief that we seek, and I'm confident that the odds of that are very, very strong, then certainly projects that the government, the administration, will have to take a rational, fact and law-driven approach to trying to stop those projects if that's what it decides to do. It can't just be on the whim of the president. And that's clearly what he's done here. The more that, you know, to be candid, the more the project is in the pipeline, the greater the reliance interest, both by the public and a company that's and a developer. So just looking at it from a lawyer's point of view, what makes this case, in my view, particularly strong is how much work has already gone into it. The farther you come away from that, the more it becomes a matter of policy. Nevertheless, the law allows for the development of clean, renewable energy offshore. It's been the law passed by Congress since 2005, and the president can't just ignore that law. So certainly developers who are applying or have already applied have rights under existing law. This is just a particularly strong case, in my view, given how much investment there has already been and the extent of the reliance interest by the state. the states in this particular case, both Connecticut and Rhode Island. Hi, Ed,
Yeah,
yes.
can you talk more about that point, reliance interest, because, you know, you're saying that you shouldn't run government like a yo-yo, it's 80% complete, but what's the legal argument? What does the law require him to do at this point?
Sure, so I alluded to that earlier, Ed, what the Administrative Procedures Act requires, and as our complaint lays out, is rational decision-making, the opposite of operating like a yo-yo. So what do I mean by a yo-yo? Today yes, tomorrow no. With no explanation as to why today it's yes, or tomorrow it's no. I'm assuming everybody knows what a yo-yo is, but I'm older than many people in this room, so for those of you who don't know, it's a little thing a round thing that goes down, and then it comes up. And it goes down, and it comes up. And, you know, the president, the way he does business isn't even that reliable. It could go down, and then up, and then down, and then halfway up, and then halfway down. The point is, what the law requires is that when an agency like the agencies we have sued here make decisions, they have to be based on the law and the facts. And there's nothing about this decision that's based on the law or the facts. So what do I mean? There's nothing in there about why the project was stopped. There's nothing in the stop work order. There's nothing in there about anything done by the developer that violated the terms of the permit. There's nothing in there about, you know, there's some vague references that the president's made about national security. All of those issues were vetted over 9 years by the federal government. So this is the classic yo-yo decision-making process where for 9 years there was a pathway to yes, and then on August 22nd, the yo-yo came back up and it was no. And you can't operate government that way. So there are 3 claims. One involves the statute that permits offshore wind itself, and then there are 2 Administrative Procedures Act related claims that are effectively go to either the lack of authority to take the action that the president's agencies did, or that they acted in a way that was arbitrary and capricious, which just means it was irrational decision making.
And do you see this ultimately being resolved with a legal solution or a political solution? The governor's asked to have a face-to-face with Trump.
Yeah, well, you know how I feel about that. I mean, I just don't think with this administration that anything other than giving them a downside changes behavior. And that requires action. I mean, you can get up and talk for all you want, but unless you do something, this president's not going to change his behavior. I know a bully when I see one. I've talked about this before. And that's what this president and his administration is. I think the difference between Trump 1 and Trump 2 is not only the president was a bully then, he's a bully now. The difference today is he's surrounded by bullies. You know, I have to say, when someone sends me a letter that says this ends now, my reaction is to laugh at it. That's not inviting a conversation. What that's inviting is surrender, and I'm not wired for surrender. Yes?
What? As we've all known for a while, this project's 80% complete. Have you seen a project of this magnitude in size stopped this far along before?
No. Anything else? Yes?
I know there's also the legal action that's being for offshore wind in general. That's before the court in Boston today.
Yes.
Why not just fold this in as another kind of exhibit?
Well, because, I think it's more than an exhibit, frankly, but I understand what you're saying. We wanted the court to know, we wanted Judge Young, who taught me evidence, by the way, at Boston College many years ago. I have a lot of respect for Judge Young. I think he's a great jurist, frankly, and was a hell of a teacher, but this is a different case. This is a case that involves a specific project that impacts Rhode Islanders and the people of Connecticut very directly. And so, in my view, it's important that we get a lawsuit on file here in Rhode Island directly involving this project, so that there wouldn't be any confusion as to what this lawsuit is and isn't about. Yes, Ed?
The New York Times reported yesterday that federal agencies are joining this battle against wind power, and one of them is HHS, looking at, I wanted to get your thoughts on HHS looking at the electromagnetic fields from turbines.
I thought it had something to do with vaccinations, Ed. You know, as many of you know, my wife's a healthcare worker, and just to divert for a little bit, this notion that vaccinations for children, it might be optional, or will be optional in some states, is, is frightening as a parent, and it's just, whatever. Anyway, what do I think of that? I don't really think anything of it. You know, like many things, it just has no moment for me. I look at the law, I look at the facts, I look at what the situation is, and we're gonna bring our lawsuit, and the other side is who the other side is. I don't really know what all that's about. And, you know, look, I try not to sleep with my cell phone right next to my head, but it's still in my room. I'm still using my microwave, and you know, I'm not, at least today, no ill effects. I'm not terribly concerned about that. I mean, on a more serious note, you know, if I had my friend, the professor from Brown, who I don't think is here, who was with us in Newport, all of these claims are, if you will, trumped up claims to try to divert attention from what's really at stake here, which is a source of clean, renewable, reliable energy in the context of a project that's 80% done. And we shouldn't be distracted by fanciful notions of threat. And I have to say that if all of a sudden there are concerns, then I have real questions about the ability of an agency that looked at this project for 9 years and never once voiced those concerns before. This is about political change at the top, not civil service work throughout an agency. And it's always dangerous when, look, there's a role, I've been in the Department of Justice, there's certainly a role for political appointees. I was one as the U.S. Attorney. But those political appointees in the past have always had a healthy respect for the subject matter experts. In this administration, that healthy respect is plainly gone, and Rhode Islanders and Americans are being hurt by that. I want to thank my friends in labor who are here, so thank you. I want to thank my friends who care about wind energy, who are also here. You know, more broadly, this is about all Rhode Islanders and what's best for them. And I believe that the way to protect their interests is by taking action. I'm grateful to the team who's worked really hard. You know, to put a case like this together, our colleagues in Connecticut and this team behind me and others worked really hard over the last 10 days. And I'm grateful for their work. All right, anybody else? If not, thank you so much for coming. Good to see you all.